Okay, we're going to talk about discharging debts in bankruptcy, what debts are dischargeable and which are not. After all, if we're going to file a bankruptcy, the whole purpose of it is try to get rid of debt obligations. So I would like to tell you then what debts you can expect to get rid of and discharge in bankruptcy, and what debts maybe we cannot get rid of. Basically, all general unsecured obligations like credit cards, medical bills, personal loans are dischargeable in bankruptcy. That usually makes up most of what we do get rid of in most people's bankruptcy filings. Secured debts like a house or a car debt are dischargeable, but most people want to continue to pay on a home and pay on a car through a bankruptcy and keep the home or the car, and that's perfectly fine, can be done. However, if you want to let a car go or have a previously repossessed car, that is a debt that can be discharged in the bankruptcy and gotten rid of. Some taxes may be dischargeable in bankruptcy, some taxes are not. I have a video on my website, a different video than this, that will talk in more detail about the dischargeability of taxes, so you can take a look at that. And if you have tax debt problems, we can figure out whether we can handle those in bankruptcy or not. Some debts are not dischargeable in bankruptcy, and if you file a bankruptcy case, you can't expect to get rid of some debts, like, for example, student loans, pretty much non-dischargeable. There's a section in the code that allows them to be discharged if you can prove an undue hardship, but the way that is interpreted by our courts is such a high bar to prove that basically student loans we simply cannot get rid of in bankruptcy, unfortunately. Child support, alimony, property settlements ordered in divorce decrees are debts that we cannot discharge or get rid of in Chapter 7 bankruptcy. A Chapter 13 bankruptcy repayment plan can discharge property settlement orders in a divorce decree. So if that's your main problem, your obligation ordered in a property settlement, we can talk about getting rid of that debt in a Chapter 13 case, but not dischargeable in a Chapter 7. Criminal fines, penalties, court-ordered restitution are also debts that are non-dischargeable and we cannot get rid of in the Chapter 7 bankruptcy case. Car accident liabilities, whether it's property damage or personal injury, even if it was caused by a car accident that was your fault, or if you didn't have insurance, generally speaking, those debts we can get rid of and discharge in bankruptcy. If the car accident was caused by a drunk driver, then it's a little more difficult. We cannot discharge personal injury or death caused by a drunk driving incident or accident. So there is a section of debts that are non-dischargeable pursuant to the bankruptcy code. Those are debts incurred by fraud, misrepresentation, or use of false financial instruments. If a creditor believes that you lied to them, promised things that you didn't do, or made false financial statements in order to get the loan or obligation, that debt may be non-dischargeable. Now, the creditor is required to file a complaint in your bankruptcy case bringing that fraud claim and must prove it before the court before that debt's going to be non-dischargeable. And the creditor has 3 months to file a complaint alleging that you did some fraudulent act to cause to incur the debt, and if they prove that up in bankruptcy court, that could be non-dischargeable. If they don't bring the complaint, then the debt would be discharged. You probably should need to know as well that your discharge can be denied or revoked by the bankruptcy trustee if we fail to accurately and honestly describe all of the information that's required in the bankruptcy petition, most particularly listing all of your assets, all of your income, and any transfers you might have made of property prior to filing. So it's extremely important that we put together accurate and correct information and provide it to the court, particularly listing assets and income. which means it's particularly important for you to be honest with your attorney and forthright and tell your attorney everything that's asked of you, and provide complete lists of assets and income and anything else that's required to be given to the court. Because if you provide false information and the trustee finds that out, whether it's during your case or after your case, the trustee can deny you discharge, or the court can deny you discharge or revoke your discharge. So honesty in a bankruptcy filing is very important. These are debts that can be discharged, some cannot be. If you have obligations that we can get rid of and discharge in your bankruptcy case, be sure to give me a call. It'll be a free visit in my office. I'd be happy to see you. Come on in and we'll talk to you then.